Well, I'll tell you, with respect to both of these requests, I think if I admitted either of these, I'd get reversed. That's the bottom line. I think that the first one, the incident involving the sister, this is clear, in my estimation, it's propensity evidence. It's an opportunity to suggest to the jurors that he's acted on in a violent way on other occasions, and therefore he acted in a violent way on this occasion. There's no connection between these two events at all. They're totally dislike each other. One involves a fight involving some kids, including the sister of the accused, and how he reacted in that particular instance, which has nothing to do with what happened in an incident which, and I haven't seen all the videos that you folks have had, or seen witness statements as you have, but it sounds like pretty clearly that at the time that the first incident occurred, and certainly I've seen the videos of the second set of shootings, that in all of the instances there was actually contact between the people leading up to the shooting incidents, and in all of the incidents there was some confrontative behavior, which is certainly subject to multiple interpretations, and I don't want to get into that. That's for the jury. But it's nothing like the incident involving the sister. So this, to me, is clearly propensity evidence. It's exactly the kind of evidence that the rule is designed to prohibit. And as I say, I'm virtually certain that if I admitted this kind of evidence, it would be end up in a reversal if there were a conviction. There's reference. You make reference to having a consistent motive. That kind of thing would be more persuasive if there were similar incidents in which there were demonstrated consistent motive. If the defendant would have gotten up on the top of the high school across the street, and every time a person who appeared to be a member of a disagreeing group walked by, take a shot at him, that certainly, that kind of behavior would be a consistent motive and would be very definitely admissible, but I don't see any connection here at all. So that request is denied. And while I agree with you that you have the burden of proof and you cannot head off your evidence by saying we're going to acknowledge this was a willful shooting, I agree with you there. I also have to be open to the voice of reason in terms of how the case is shaped out. The defense is clearly conceding the issue, and the law is also clear that when that's the case, the judge has to look at it a little bit differently. Certainly if they walk in here on day of trial and start claiming that it was the acts of shooting not willful, then I'll take another look at it. So I certainly don't want to suggest to you that there might be a different ruling, but it would put a different light on it for sure. So the request is denied. The Proud Boys evidence, at this point I don't know, and perhaps you have other information which I don't know about, but I don't know whether there was a prearrangement to meet these people or if there was an awareness of who these people were. I have to tell you, I never heard of the Proud Boys before this case. And you cited a Seattle newspaper, and I'm not going to rely on a newspaper account about what an organization is, whether they're a hate-inspired group or whatever they may be. There's such a spectrum of groups in this country, and it seems to be more every day. But and I don't think it's for the courts, except in the most appropriate circumstances, to be making determinations, and certainly not on the basis of an article in a newspaper in Seattle, about what an organization is. But assuming that these people are a known group that is inclined towards violence, and particularly violence of a particular type, again, directed against particular people, there's still no suggestion in the evidence that's been offered to me that this was anything other than a happenstance occurrence. And even if that isn't true, what the scope of the defendant's understanding was, and obviously it is an unfortunate fact that this case has become a surrogate for a lot of emotional reaction that has nothing to do, or little to do, or nothing to do with the issues in the case. But if this man is accused of these crimes, which could send him to prison for life, and he encounters some people who embrace him and start to, can we take pictures with you, and somehow make him feel better about himself, and he reacts by smiling with them and taking some pictures, for me to let that in as evidence of a motive that existed 4 months earlier, can't see it. Absolutely not. Again, I would expect to be reversed if I did that.